You may be seated. Good morning, Council. We are here for oral argument in case number CV17-0784, HTA BOSWELL et al. Versus Sun Health. As you've probably heard before, these proceedings are being video and audio recorded, so we'd be grateful if Council, as you approach the podium, give us your name and the name of your client so that the recording is clear. Each side is allotted 20 minutes for your argument, and the appellant is free to reserve any amount of that time to use in rebuttal, but you are in charge of keeping track of your own time. The clock on the podium will reflect the total that you have remaining, including any amount that you're hoping to reserve. Please do keep in mind we've read the briefs, we have viewed the record, we have conferenced and discussed the case, and with that, please proceed with your argument.
Judge Perkins, Judge Thompson, Judge Winthrop, and my esteemed colleague, my name is Mark Nadeau with the law firm of DLA Piper, and together with my of counsel, Laura Cam, we are here representing the appellants, Healthcare Trust of America, and the lessees. Our client representative is present as well, Robert Milligan, who is the Chief Financial Officer, Treasurer, and Secretary for Health Trust of America. I will reserve 3 minutes for rebuttal. And as I begin, may I simply observe that it's not often that a lawyer appreciates being in front of 3 appellate judges for a grilling, but of course today is November 6th, and the avoidance of television and other advertising for the moment is a delightful respite. In our limited time today,
that's such a calming influence.
There you have it. In our limited time today, there are 4 subjects that we propose to address on behalf of HTA. First, the preemptive right at issue and whether it became an option. Second, is there clear error by the trial judge in reliance on cure periods and the notion that there can be no lawsuit if there's no ongoing transaction to enjoin? Third, whether there is clear error in the dismissal of the fraudulent concealment claim. And fourth, clear error in the application of the prevailing party attorney's fees award. As you may appreciate, we are here seeking that the case be remanded to the trial court and that the award of attorney's fees be vacated. Let me turn first to the standard of review. And I pause you here because it's difficult in the Court of Appeals to undertake a case that has been dismissed on a complaint. No amendment was granted. Only 1 complaint was filed. No discovery, no summary judgment, none of the things that show up in your ordinary appellate practice. As a general proposition, you are looking upon cases that have a much more detailed and fulsome record. That is not this case, so we need to pause on that and reflect on the narrowness of what is before you and the dearth of what is before you. In that regard, you do have de novo review of everything that we're talking about today. All the facts are to be construed in favor of HTA. Any question of fact or mixed question of law or fact is yours and can compel remand. If you find yourself today about to ask me a question and it involves facts, or your determinations on the case would be better resolved if you knew facts, then again you should remand. The preemptive right, whether it became an option. The leases were made in 2004. And that's before Banner ever arrived on the scene. Section 6.1 of the lease, you have seen it, provides in the heading for a right of first refusal. Now, the terms of that right are defined in the language that follow it. You know, there has been much back and forth over whether or not it's a right of first refusal or a right of first offer. Let us simply say what you're supposed to do with that right is determined in 6.1, where it tells the parties how they are to act. And in that, we believe you should apply ordinary construction of contract. It compels the performance of straightforward language. Just do what the clause tells you to do. And if you do not, and there is no ambiguity about what you're supposed to do, then, as we alleged in our original complaint, our first and only complaint, you are in breach. Now, if it amounts to a right of first refusal in the ordinary sense, and we as lawyers sometimes tend to simply grab a term and import into it our own thinking about what it means. Here we ask you, of course, to reflect upon the contract language itself, but there's no equivocation on the question of when it is preemptive, and that's if there's going to be a property transfer. Now, in 2016, precisely when in 2016, please grasp this point, precisely when in 2016, unknown to us at this moment, Banner and Sun Health entered into negotiations and came up with a lengthy document. Now, it is sealed in your record at 29. There's an unredacted copy that was provided days before the litigation commenced. The final unredacted copy was provided to the court sealed after the litigation commenced because Banner and Sun Health did not want to provide it. It contains some very interesting language, so if you have not read this, we suggest that you do take the time to look at the unredacted copy at Record 29. Critical to you, I suggest, and the reason I have it here in hand, is the length of this legal document. If it's merely about transferring title, you know there are easier ways to do that. Quitclaim deeds, warranty deeds, other things. Why? You should ask yourself, does this one have all of the extraneous stuff within it? And is it intentional? Is it bad faith? Is it designed to occlude? We alleged that it was in our complaint. What is it really about? It's about a non-compete agreement where Banner takes the hospitals and Sun Health takes the senior assisted living centers in Sun City. Find some other hospitals out there if you can. Find significant senior assisted living. Sun Health is major with more than 800 residents. But the contract is about that splitting up of turf, and contained within it, after the exchange of many dollars redacted in the public record, are three things that happen. Number one, there's a clause, 2.2.1. Parties will convey to Banner the real estate. No equivocation here. Nothing at all that says we'll test the market, we're going to anybody else. There's a we will convey, and what's notable? At the end of that paragraph, fee simple, and they ultimately say warranty deed. Special warranty deed. So the parties will convey to Banner shows up again in 2.2.2, and then again in 2.2.3. Parties will convey. Very short paragraphs narrow how will you do it. You're supposed to do it within 90 days. But then, if you haven't caught on to this, look at 2.2.3 H7. We call that the pocket conveyance. It's a conveyance that whether or not the preemptive right is invoked or not, or anybody contests, if it's contested, they're still conveying a pocket conveyance in 2.23H7. It's called the conveyance contribution. We won't publicly record it. Think of this as you might as a stipulated judgment or something. We're going to take it and stick it in our pocket. That's called something that is peculiar. It's certainly orchestrated, and it seems well outside the ordinary of any sale and preemptive rights. What follows?
Again, you can come back
Yes, Judge.
as you choose, but isn't there ultimately a provision that says all that's subject to the tenant's rights?
No. Okay? In this agreement, instead of saying it's all subject to, there's a compulsion that you must sue the tenant for declaratory relief. This is important because in the briefs before you, they tell you that they amended this document, and then they changed it to say they will not do anything and they have no desire to sell as long as the tenant doesn't contest, or as long as the tenant contests, they have no desire. That is a complete misdirection and approaches bad faith or fraud, because by that point in time, this had matured into an option. And so they're backpedaling moments before they appear in front of the court, and they amend their own document. But what do they amend, Judge Thompson? They don't amend that there's no pocket conveyance. They extend the time for it. They don't take it away. So as you and I sit here today, we don't know if the time has been extended yet again. There were 5 amendments, but that was into the summer of 2017. Where are we now? That's unknown to us.
So you're suggesting that this provision that I raised would work only in this way, that Boswell would have to sue the tenant to avoid being obliged to convey the property to Banner. Is that right?
Sun Health would have to sue the
Yes,
tenant.
okay.
Correct. Yes. And so they would sue the tenant in a declaratory judgment or action or otherwise. And it's contemplated that they would issue estoppel certificates, and if those weren't granted, then there would be forcible evictions and breaches, etc. But the last sentence of that paragraph is compelling because it says, and will appeal if Banner picks up 50% of the cost of the appeal. And in the 2 sentences right before that, Banner is granted the right to determine the form of action involving the tenant. But Judge Thompson...
It's not just a compulsion to sue the tenant, but also to appeal from an adverse determination of that.
They don't have to appeal unless Banner will pick up 50%.
But if Banner will pick up 50%.
Correct, then they're going. Okay? And immediately before that is the proviso that Banner can weigh in and elect the various causes of action. So if you look through that whole clause, they're obviously aware of the preemptive right. They're trying to jockey around it. There's no question that this agreement tries to jockey around it. Okay? That's where this so-called preemptive right...
Well, they initially tried to have you expressly waive, correct?
No, they did not initially at all. Instead, they tried to cram it down the throat. That is, they did this in December 29th. You'll appreciate taxes. Okay? Following that, on January 13, their current president and chief executive, Joseph LaRue, who I think is in the courtroom today, sends a letter. And he does not ask whether it's okay if they sell in the fashion that they're doing it. He does not test his tenant on the question of the preemptive right. Rather, the letter on January 13 says clearly, we are transferring, and there's a permitted exception. Now, they've now dropped that argument. They don't want to go to the merits of it. But they've said, because in 2016, we were selling in conjunction they say, with a sale from 2008. Okay? That is fanciful. It is misleading.
What happened in 2008?
The hospitals were sold to Banner back in 2008. Sun Health was your operator out there up until that point in time. So they say it's in conjunction with 2008, but that is merely lawyering, right? Look at the thickness of this document, how long it took to negotiate. How do you get to that?
Your construction of that provision.
Yes, sir.
That I raised, about this deal being subject to the tenant's rights. Your construction of that as being essentially a compulsion to sue tenant and to appeal if Banner participates. Is that based on the nature of this pocket conveyance? That is,
pocket conveyance follows it, but you're fair to ask the questions you're asking.
You said that the conveyance had become an option at this point.
The conveyance occurs on the desire to sell, and the transfer obligations occur on December 29th. Notice to the tenant follows on January 13th. All of the case law we have cited to you says that at the point notice and the transaction are a fait accompli, the preemptive right matures into an option. So our view is, as of January 13th, that preemptive right was an option.
Your preemptive right.
Correct, sir. Yes, absolutely. And the box to check there is the question of when did HTA get full details of that sale. They didn't get it until the litigation commenced, and we got it there, right?
Because your time is rapidly advancing, can I just ask you?
You may.
Directly about Judge Broadman's ultimate decision, which was because this didn't happen, then you don't have a case. I mean, is that essentially what the trial judge ruled?
Yes. I mean, he said there was a cure period of 60 days. My opponent made that argument to him. Of course, if it's an option, there is no cure period. It's not a standard default within the lease. It now becomes vendor-vendee, and they can't take that right away of an option to purchase the land by virtue of a cure period. That's an imponderable, uncurable, doesn't happen, cases rejected without contest on that. The next thing,
because this deal had not gone through and may never go through, your client wasn't hurt, so there was nothing to argue about.
But of course, the latter part of what you just said, my client has not been hurt, is a fallacy, because they had the option to get the dirt. And they're the tenants with the buildings, and they've invested millions of dollars in it. They could have merged the estates, you follow. So the other aspect, I want to be quick with you and upfront on this, is the other aspect of that decision about no harm, no foul was their third amendment to the agreement, in which they said on April 28th approximately that they had no desire to transfer so long as tenant contested. Okay? That comes day late and dollars short, because the option, the preemptive right is transmuted into an option in January. You can't take it away by then backing up and going, oh boy, we made a mistake here. With that, I'll close and save a few moments for rebuttal. Thank you.
Morning, Your Honors. May it please the Court, I'm Daniel Delaney with the law firm of Drinker, Biddle, and Reef, and I represent the appellee Sun Health in this matter. I want to address, I think, 4 issues this morning, if I have time. First, the trial court properly found that all three contract claims asserted by the HTA plaintiffs were properly dismissed because the right of first refusal on which each was premised had not been triggered by the plain terms of each ground lease. Section 6.1.3 provides that if the landlord is proposing a transfer, merely proposing a transfer that is part of the sale of the hospital property, that the right of first refusal for the tenant shall not apply at all. So if that's what we're proposing.
What was the section number again, please?
The section of
The one you just cited.
6.1.3. The tenant's right of first refusal is in section 6.1. Section 6.1.3 provides that the tenant's right, the whole section 6.1, the whole tenant's right of first refusal, shall not apply to any transfer that's proposed by the landlord as part of the sale of the hospital property. Second, the trial court properly found that plaintiffs' claims were not proper because they had not provided the contract required cure period. They've got to give us notice of default and give us an opportunity to cure. They can't refuse to even give us an opportunity to cure and then say, well, we don't think that any cure you could come up with would satisfy us, therefore we're not going to comply with our contract. Third,
The cure would be offering it to sell it to them or something?
well, it depends on, frankly, Your Honor, on whether or not 6.1 is a right of first offer or a right of first refusal. If it's a right of first offer, the cure would be, okay, here's the terms that we would offer to sell it to you on. If Section 6.1 even applies, because I want to get into the actual contracts here, because that's why this case is simple. All you have to do is look at the underlying contracts to decide whether or not Sun Health is proposing a transfer in connection with the sale of the hospital property, or whether it's proposing a sale to anyone who wants to buy. That's not what was going on when you look at when you just look at the plain language of the documents here. And I want to get into that. But third point I want to make, and I'll get to it, trial court properly dismissed the remaining claim of HTA Lakeview Plaza for fraudulent concealment because the landlord did not owe disclosure duties to its tenant, either as a matter of common law or under the contract provisions here. And the allegedly omitted information was already disclosed to HTA years before. Lastly, if there's time, I'll address that the trial court's award of attorney's fees to Sun Health was proper, as it was a successful party, and contrary to appellant's argument, that's not subject to a de novo review of standard review. That's a standard of review for abuse of discretion. All right. Each ground lease here provides a right of first refusal to the tenant in Section 6.1 and to the landlord in Section 6.2. Although the right of first refusal language is similar for each, there's two important differences between Section 6.1 and Section 6.2. The first is that there's an exception to tenant's right of first refusal set forth in Section 6.1.3, stating that, quote, Section 6.1, where the right of first refusal is, shall not apply to a proposed sale or transfer by a landlord, either A, in conjunction with the sale or transfer of all or substantially all of the landlord's hospital property, or B, to an affiliate. Key language here is proposed. All the landlord has to do is propose. If it's proposing a sale that would only occur, sale or transfer that would only occur if Section 6.1.3 were deemed to apply, then Section 6.1 simply does not apply. That's why this case was an easy case for the Superior Court to dismiss, because all you have to do was read the contract. First, you read the lease and see that there's an exception, and second, you read what Sun Health wrote to the tenants, and you read the agreement between Sun Health and Banner. There's also a difference in the tenant right of first refusal and the landlord right of first refusal about when the ROFR must be offered. The tenant, when it wants to sell its property, must offer the right of first refusal to the landlord before signing a contract. That's in section 6.3. There's no such pre-signing requirement imposed on the landlord. Why? Well, because that really wouldn't work with section 6.1.3, would it? How would the landlord propose a sale or transfer in connection with the sale of its hospital property to be tested in the courts or to see whether or not the tenant would agree if it can't do that before first invoking section 6.1 for the tenant? Because section 6.1 doesn't even apply if we're proceeding under 6.1.3. So the landlord has the choice here about selling either to anyone it wants at the best price, or only proceeding or only desiring to sell if the sale could proceed under the exception to tenants' right of first refusal in section 6.1.3. So you start by looking at the January 13th, 2017 letter that Sun Health wrote to the tenants here. It's Exhibit 19 to the complaint. That advised tenants that Sun Health was proposing to proceed with a transfer to Banner under section 6.1.3. It's part of a sale of its hospital property. Now, the tenant's free to disagree with that, and the disagreement would be settled by a court if Sun Health wanted to push it that far. Or Sun Health could decide, we're not going to push it that far. We're not going to take it there. And that's so far as what's happened. Sun Health has not pushed it into court. We have not filed a declaratory judgment action. We're not required to under the agreement we have with Banner. So next you want to look at the agreement itself between Banner and Sun Health. And that specifically provides that the proposed transfer to Banner will not occur unless one of three conditions occurs. One, the tenant agrees that this proposed transfer is compliant with section 6.1.3. Here Sun Health asked the tenants if they would do that. They didn't. Other tenants might have. Or even if the tenant takes the position that it does apply, they could waive it, and then we could proceed. Or we could proceed if we got a court of competent jurisdiction to issue a final and non-appealable order that this proposed sale or transfer to Banner did fall within section 6.1.3. But there was never anything said or written in any document, nothing in the complaint, that we ever said, Sun Health ever said, that it would transfer these properties, that it had any desire to sell or transfer these properties if it didn't comply with section 6.1.3. All right, now Mr. Nadeau referred to section 2.2.1 H7, and I think he called that a pocket transfer.
Pocket conveyance.
Yep.
Pocket conveyance.
Pocket conveyance. Your Honor, that's not what this is. If you read the provision, it talks about, as part of the charitable support that Sun Health would provide as part of the support and maintenance agreement that they had signed with Banner when they sold the hospital properties. As part of that charitable contribution, once the leases terminated or expired, we would make those conveyances, which we're free to do. The conveyances aren't being made now. They're not being made in violation of the lease. Once the leases are over, Sun Health can do whatever it wants with the property, sell it to whoever it wants. That's all that's happened here. But the Third Amendment only made clear the Third Amendment to the support agreement that Mr. Doe referenced. All that did was make clear that we will not transfer these properties unless that transfer falls within the exception to the right of first refusal. And for that, we can either ask the tenants to agree, ask them to waive, or a court of competent jurisdiction agrees with us. If they don't, the consequence is the properties don't get conveyed. Not that we now have a desire to sell them or transfer them to the highest bidder or to the landlord or to the tenant. Remember, a right of first refusal, or if you call it a right of first offer even, and the tenant has taken the position, I'm not sure if they're backing off now that this is on their position, this is supposed to be a right of first offer, but those rights don't give the tenant the right to require the landlord to sell on terms that the landlord doesn't want to sell on. The landlord, as the owner of the property, can decide, well, we want to sell to the highest bidder, we want to sell to whoever will give us the best price, or they could say, no, I'm only interested in selling or transferring these properties if they qualify under the exception to tenant's right of first refusal. That's all that's happened here. So nothing's ripened.
At the risk of making you repeat yourself, could you tell me again what the language in 6.1.3 relating to the term proposed, what that is and what it means for your argument?
Yeah, what it means is that
told us to pay note to that term.
Correct. Section 6.1.3, Your Honor, says permitted transfers is the title. Section 6.1 is tenant's right of first refusal, and Section 6.1.3 is permitted transfers. This Section 6.1 shall not apply to a proposed sale or transfer by landlord of the premises or landlord's interest in this lease, A, to any party in connection with landlord's sale or transfer of all or substantially all the hospital property, or B, an affiliate.
You're saying this is A?
This is A, because if you look at what we said that we are looking at a transfer as part of the sale of our hospital property. Our January 13th, 2017 letter specifically referenced Section 6.1.3. The way the amended support agreement was originally written was that if one of the tenants disputed that the transfer qualified under Section 6.1.3, Sun Health could go to court and file a declaratory judgment and ask the court to decide that issue. On the other hand, if the tenant was silent and didn't tell us one way or another whether they agreed with our position, we could transfer the property, but there was a requirement in Section 2.2.3H5 for Banner to transfer the property back so that we could then have a declaratory judgment.
So as part of your assertion with regard to 6.1.3, that since that section posits the existence of a proposal, it couldn't be a breach for you to negotiate with Banner.
Correct. We could be wrong on our interpretation of the provision that this doesn't qualify as a sale of all of the hospital property or substantially all of the hospital property, and we could test that in court. But we still get to propose that. And if that's all we're proposing, if we're only telling Banner that we will agree to transfer the properties if they qualify under Section 6.1.3, then we are not subject to Section 6.1. Section 6.1, quote, shall not apply in those circumstances. And if you look at the letter that we wrote on January 13th, 2017, Exhibit 19 to the complaint, we never said that we were going to transfer them, even if such a transfer did not qualify under Section 6.1.3. It would only be transferred if it qualified as a transfer under Section 6.1.3. So until we tell the tenant that we are willing or desiring, is the word desire in Section 6.1, until we desire to sell to anybody outside of Section 6.1.3, there is no right for the tenant that is ripened, whether you call it a right of first offer or a right of first refusal. I would like to get to the fraudulent concealment claim, unless your honors have any more questions about what happened here with the conveyance issue.
At the risk of cutting your time, explain the last part that you just said about desiring to sell outside of 6.1.3.
Right. Section 6.1 says that if landlord desires to sell or otherwise transfer, okay, then we tell the tenant we want to sell, and we've either gotten an offer, and we think we like this offer, we'd like to take it. Tenant, do you want to match it? Or we can say, we haven't gone out to the market yet, but we do desire to sell. So, and we think we'd sell the property for $1 million. Section 6.1 then says, tenant, you tell the landlord whether you want to take that or not. And if you don't take it, then the landlord can go out and sell the property to anybody they want, as long as it's at least 95% of the price.
That's what you mean by outside of 6.1.3.
Right.
Somebody else.
But that whole provision does not apply if what we're proposing to do is to sell or transfer as part of a sale of the hospital property. And that's the only desire we had. We did not desire to sell or transfer unless it qualified under Section 6.1.3. If I could get to the fraudulent concealment claim very quickly, all right. First, there's no duty to disclose here. That's why, the case was easy as a matter of law. I think the tenant concedes that there's no duty to disclose as a matter of law. They posited that there was a duty to disclose as a matter of contract right. Well, there's no duty to disclose as a matter of contract right either, because if you look at section, and they're relying on Section 6.1 for that. But under Section 6.1, we did not have any duty to tell the tenant that we would be willing to sell, because Section 6.1 doesn't require us to go to the tenant before we've talked to anybody else. Doesn't require us even to talk to the tenant before we've entered into a contract with somebody else. It's got to be contingent on the tenant waiving. Such a contract would have to be contingent on getting around Section 6.1, but we're free to actually enter a contract. How do we know that? Because the parallel right for the landlord's right of first refusal in Section 6.2 specifically says that the tenant has to come to us first before signing a contract. So there's no duty to disclose here, and I think the record. I'll just rely on the record for that, Your Honors. Everything was already disclosed to them, anyways. I think the record clearly establishes, and the tenant did not dispute that these were central documents central to our claim, that the agreement regarding ground leases was provided to the tenant years ago, and therefore the tenant knew that once it sold its leasehold interest to Banner had a mandatory purchase obligation to come to Sun Health and buy that property.
30 seconds for return.
Your Honor, I'll finish up. I ask that the court affirm the judgment of the Superior Court in all respects, including its award of attorney's fees. Thank you very much.
Thank you. My opponents changed their argument here and start talking about 6.1.3, but of course if you read the transcript at the trial court, you will not find that same argument. even worse, of course, he changes the language as he reads it to you. He says it doesn't matter, it doesn't apply, this right of first refusal, right of first offer, to a proposal, okay? But he changes the word. He said in connection rather than in conjunction with landlord's sale or transfer of the hospitals. The hospital sales occurred 10 years ago. So we alleged in our complaint that was bad faith. They were trying to weave a story. Read, if you will, he quoted to you from the right of first refusal, which we've characterized as a first offer, and he was answering your question, Judge Thompson, about what happens if you desire to sell. And he says, well, it doesn't require us to do anything. We don't have to tell them in front. There's no duty. It says, let's be straight, desires to sell or otherwise transfer the premises or landlord's interest in this lease for consideration, landlord shall first offer to sell such property to tenant. Straightforward. It's been mischaracterized here today. With respect to those two sections on the notion of a proposal, take your time, sit down, read the LaRue letter from January 13th. It is implausible that you could come to the conclusion that it's a proposal or a question about whether or not there's a permitted exception. It uses affirmative, unequivocal, compulsory language that says we're selling, and it's subject to the permitted exception, which, of course, it's not, because it was hospital property 10 years ago. Nothing further.
Thank you for your arguments, counsel. We'll take the matter under advisement, and we're going to clear the courtroom for a short recess. Or bench.